Thank you all for joining us tonight. We'll get started in just a couple of minutes. Let people come on. We're a little bit late. I hope no one had a hard time. Absolutely. It's good to see you all tonight. Thanks for being with us so late. I guess it's not so late. It's so late for Danica, who's joined us from Washington, D.C., but not for the rest of us. I'll just give it a couple more minutes, but really appreciate you all joining us tonight. And we're going to record this as well and have the slides available publicly. So, you know, if you have kids that want to watch it down the line, you'll be able to. I'll just give it one more minute. All right. Are we pretty good, Danica? Everybody out of the waiting room? Okay. Well, again, thank you all for joining us this evening. My name is Donna Beltran, and I work for Generations United's National Center on Grand Families, which is located in Washington, D.C., but I work out of my home in Bellevue and have now for close to 18 years, and I've worked for Generations United all those years. Anyway, I'm pleased to be joined tonight with Celeste Miller from the King County Bar Association. I'm sure many of you know her. She's the statewide kinship care legal aid coordinator. And Zan Gerson, who is with Menace Estate Planning, and she will share her expertise with us. So we're in for a treat and getting exposed information that we don't always get to hear. And it's important information. So with that, welcoming you to our webinar, and starting off by letting you know a few housekeeping tips. Just that the session's being recorded. All of our lines are muted except for mine because I'm talking. If you want to ask questions at any point, because if you're like me, I can't retain a question, so I like to get it out right as I think of it. Type it in the chat box. And then we will get to those questions at the end of Celeste's presentation and at the end of Sam's presentation. And then if we have time for more chat at the end, we will do that as well. And if you don't want to type out your whole question in the chat box, just say, I'd like to talk. And then when it comes to questions, you can unmute yourself and ask it directly to the person. Sometimes that's easier. And to do that, you just click unmute in the upper right-hand corner of your video square. Or if you're on the phone, you press *6. At any rate, if you have any problems, Danica has joined us with Generations United. You can chat with her in the chat box, or there's her email address as well. Everyone will get the slides and a recording sometime next week. It'll be posted publicly on grandfamilies.org. We'll also send out an email with everyone who's joined us tonight. Thank you so much again. So this webinar is made possible by the Thomas V. Giddens Jr. Foundation, which is here in Washington State, and we really thank them for their support. Tonight, we're going to first talk about the different legal options for custody that kinship caregivers have here in Washington State. We're using that as the framework to talk about how you can plan for the children in your care in the event of your death or disability. Then Zan will take over and really go through the array of important estate planning that we should all do so that we make sure that our wishes are met when we get sick and when we pass. So we're going to go through a range of legal options from permanent adoption, being the most permanent, to revocable. And by that we mean that the Birth parents can revoke it, can take it away at any time. It's really the power is theirs. And those are power of attorney laws and the like. And we're also going to just touch on a little bit some of the legal options that impact those of you who are caring for children who are in the legal custody of the state and you're their kinship foster parent. I know that's not most of you, but we'll just touch on it a little bit. So we will lay out the explanations. They're going to hear more detail about all of this from Celeste. On the next slide, you will see kind of the array of permanency options that are out there. On the left-hand side are kind of those private options. So if you don't have any state involvement, your child that you're raising is not in foster care, and you are one of the it's much more common to be caring for children that are related to you outside the foster care system. So I know that's probably the majority of you who've joined tonight. But we're going to go through the array from everything that's very informal. You know, mom dropped off her daughter in the middle of the night and you've been taking over and you really don't have anything in writing, to kind of this power of attorney and temporary parental consent forms where the parent has to kind of give you power because the parent has inherent power and you don't, and you have to go to court to get kind of a legal relationship with the child, right? And then the non-parent custody, which many of you probably have, and now it's going to be changing to the Title 11 minor guardianship, and that's what people are going to get from now on, although your non-parent custody will still be effective. And then all the way up to adoption, which is when you become the parent, and that's, of course, the most permanent of all. And then on the state-involved side, so when the child's in foster care, the vehicle to get guardianship is totally different. So different law, basically, a different mechanism, different court, and you get guardianship that way, and that would provide the pathway to what's known as RGAP, relative guardianship assistance, and that is where if you are a licensed foster parent and the relative has been in your care for 6 months or so, you can exit the foster care system and get this monthly financial support to help you meet the needs of the child. On the adoption side, it works similarly. You exit to adoption and you get adoption assistance ongoing as well. So that's kind of the array, the continuum that we're going to discuss. On this chart, you'll see kind of the private options. So starting with that informal agreement, you know, mom just dropped off her daughter with you, that kind of situation. So how do you plan if, you know, for when you die or when you become disabled, what happens to that child, right? And this is the trickiest of all because you don't have a legal relationship to the child. So what do you do? Well, you can collect as much paper as you can that shows that you're caring for that child. So any school records you have that shows your address, your name on it, that you're the contact. Any healthcare records that show you're the contact for this child. If you've signed a healthcare affidavit, putting that in the file. Any TANF non-needy benefits that you receive or anything like that. And then any documents that you show that you're related to that child, like a birth certificate or family records. And kind of make a big folder of that. And then make a plan with someone you trust. So say you really want to, if the child, when you pass and the parent's kind of out of the picture completely and you want to say that your neighbor is going to take over for raising this child, then make a plan with that person, type it out, sign it, come to an agreement, maybe go get it notarized, go to the bank and have a notary sign it, and just keep it all together. It doesn't have any legal effect as such. You can't go to court with this, but it shows at least your wishes. And so it gives you some protection and the child you're raising some protection. Now, if you're the parent has given you power of attorney or a temporary parental custody, work with them. If the parents are in the picture, try to work with them to make a plan for what will happen to the child if you die and the parents die, and really come up with a plan with them. But they are the ones who have legal authority, so they're the ones who are going to have to do the paperwork. If you have a non-parent custody, or if you're getting a Title 11 minor guardianship, you will have more ability to name someone to take over. Through that process, you can name what's called a successor guardian. and that person would step in your shoes in the event of your disability or death. It's unclear what happens with those of you who have non-parent custody and how you name that successor. And you're really going to kind of be trailing the, trailblazing on that one, but that you should be able to modify your non-parent custody order and name a successor. It's not going to be the most obvious thing, and it's going to take a little working with the court, but it should be possible. And then finally, if you have adopted the child, you can, like any parent, any birth parent, you can name the guardian in your will who would take over in the event of your death. And you can also name a standby guardian to take over if you become disabled or die. And a standby someone, those are laws that were created in the wake of the AIDS crisis when parents were getting very sick, really couldn't parent, but still wanted to be the parent. So this standby steps in the event of disability, and they can help with the caregiving without the parent or you as the guardian losing your rights over that child and losing your ability to make decisions for that child. So it's a nice mechanism that was just enacted in Washington, and it goes into effect in January. The next slide shows the options if your child is state involved. So if your child is in foster care, the state has legal custody of that child. No one else doesn't, you don't. So the state has custody. In that situation, if they're in foster care, we suggest that you work with the child's caseworker and really try to make sure that they have engaged a lot of family members for that child and really kind of have a network of backups that could be kin that aren't related to the child but are like close family friends, godparents and the like, and make sure that they have a plan and a network of support around that child. If you're in the child's in foster care, you're a licensed foster parent, you can get what's called Title 13 guardianship and exit the foster care system with that child and get this RGAP, which is this monthly financial assistance. RGAP has been around for quite a few years. Not many people take advantage of it because it's kind of a best kept secret, but it is out there, and the monthly rate is up to the foster care rate, can be up to the foster care rate. You have to negotiate it. You have to put that RGAP agreement in place before you get the Title 13 guardianship. That's critical. That's part of federal law. And as part of that process, you name a successor. Again, on this side, like to take over if you die. And that successor, this is interesting, doesn't have to be a licensed foster parent, doesn't have to be related to the child to get that monthly financial assistance and step into your shoes. On the adoption side, it works similarly. And if you do adopt a child from foster care, then you're the parent. You should create a will and name a guardian for your child in that will. You'll also be able, if you've adopted from foster care, to get some kind of adoption assistance that's similar to the guardianship assistance, so it's monthly financial support. And as well with the adoption assistance, you can name a successor to take over in the event of your death or disability. So that's kind of the big overview of of all the options and the planning for the child in the event of your death. But I'm going to turn it over now to Celeste Miller to walk you through kind of option by option and give you some more detail. Celeste?
All right. So I'm Celeste Miller, and I know some of you. My job title is Statewide Kinship Care Legal Aid Coordinator, and I've been in the position for a little over a year. And I am going to talk specifically about the non-state involved legal relationships that are possible in Washington for custody, basically. And then there are notes on my slides about how the legal relationship is related to estate planning or planning for after your death. And Zan, after I'm done, will go further into specifics of estate planning. So in terms of adoption, oh, I also wanted to say that we will take questions. When I'm done, there'll be a time for questions. And also when Zan is done, there'll be a time for more questions. If you want to type questions into the chat, feel free to type them in and we'll be able to look at them when we have the question time. I just wanted to say that because I saw a question in the chat. Okay, so adoption is a very permanent legal option for kinship caregivers. It provides full parental rights to the adoptive parents. As Anna said, that means that you legally, it's like you had that child yourself. This can be done legally. You can do this with a private attorney, a private adoption agency, or through foster care, either as a placement for a foster child, or sometimes people who are not foster parents will adopt a child from foster care. In terms of doing an adoption, the birth parents must agree to the adoption, or they must have their parental rights terminated by a court. So that can happen in dependency court through termination of parental rights, and that's if the child is in foster care. Or it can happen in a contested adoption, which is relatively rare, but it can happen. If it is done through the state system and the child has special needs, and this is something Anna touched on already, the adoptive parents may be eligible for adoption support payments. So that's something through DCYF where if you adopt a child who has special needs, you can still receive payments from the state. If you adopt a child privately without, dealing with DCYF, or if the child doesn't have special needs, you don't receive any monthly payment like you do in foster if you're a foster parent. In terms of the parental rights that you gain when you adopt a child, that allows, one of those rights is being able to name a guardian for the child in your will. That's something that only legal parents can do. Another thing that you can do based on the new law that is coming into effect in January is naming a standby guardian to take over for you. And you can name the person long before they actually need to take over. So you basically say, I want this person to take over for me as a standby guardian in the event that I become really sick or incapacitated or die. And then when it seems like something like that may be happening, that's when you would go to court and say, we need the named standby guardian to actually become the guardian now. Okay, and then moving to the next slide. The next legal relationship that I want to talk about is non-parent custody and the Title 11 minor guardianship. You may have heard that non-parent custody, that law in Washington is being repealed. It will be gone on January 1st of 2021, and that the Title 11 minor guardianship law will replace it. So Title 11 is a really big act that includes adult guardianships, but there's a specific portion called Article 2 that is all about minor guardianships. Excuse me. So I have I'll talk a little bit about what you do if you already have non-parent custody in a minute, but first I wanted to talk about if you have, in the future, if you get minor guardianship under Title 11, and if you have non-parent custody as well, This is legal, this is a type of legal custody, but it's not the same level as adoption. It does not give you legal parental rights. The parents still have those. But the parents' rights are limited by the guardianship or non-parent custody because they basically have been found by a court to not be able to take care of their children. However, it's really important to know that non-parent custody or minor guardianship is not permanent and that it's possible for the parents to prove that they can take care of their child again. And they have an avenue to do that through the law. However, they have to prove it, as I mentioned. They have to do that by filing a petition to terminate non-parent custody or terminate the guardianship. And they have to prove that they actually can take care of the children and that the reason that they lost the custody in the first place no longer exists. Or if you and the parents agree, you can terminate a non-parent custody order or a guardianship. But if you don't agree, it has to be done through court. Parents can't just change it without going to court or having your agreement. In terms of planning ahead, if you have non-parent custody or minor guardianship of the child, you can't name a guardian in your will for the child. Only the parents can do that because they still have those rights. But you can request a successor guardian if you have Title 11 minor guardianship, which you wouldn't be able to get until January at the earliest. But also, I believe if you have non-parent custody, final non-parent custody order already, you can use the same process. There's a way in the minor guardianship law to file a petition with the court to ask for a successor guardian, so someone who will take over for you in case of death or other serious reason. So it's like standby, but it's different because it happens right when you ask for it. So moving to the next slide. As I mentioned, I wanted to touch on this a little bit more because I know that it is a huge question for a lot of people. And as we get closer to the end of the year, it's really looming question. So if you have a non-parent custody order, a final order, before the end of this year, it will remain valid. The way that you know if it's a final order is it should say final in the heading. If it doesn't say final, you should probably check with your court or with, if you had an attorney help you, double check them. Usually if your case still has court dates or still happening in your case, then you don't have a final order yet. You may have a temporary order. So it's important to double check that. If you have that final order, it does not go away. It does not get canceled. The parents cannot show up on New Year's Day and say, you don't have non-parent custody anymore. So that's just really important to know because I've received a lot of those questions. Could you go back to the previous slide, please? Thank you. In terms of if you have this non-parent custody order and the non-parent custody law is going away, what does that mean in the future? So in terms for the parents to regain custody of their child, they have to file a request to terminate a non-parent custody order, but they have to do it through the guardianship law, through the new law. So the new law requires parents to show that the reason they lost custody no longer exists, among a few other things. So it's just very important to know that your non-parent custody order, if you have one, will stay in effect and you will still have custody. That can only be changed by you agreeing with the parents and going to court to change the custody order. Or if you don't agree, it can only be changed by a judge, and the parents have to prove that they should have custody back. So I just want to dispel that fear and worry that I know a lot of people have, that the parents will be able to come take their children back at the start of 2021. In terms of temporary orders, it's a little bit more complicated. The new law says all orders under non-parent custody law will remain valid. So, you know, some attorneys could interpret that to mean that includes temporary orders. Some counties have already, like King County, have already decided if you have a temporary order, it will go away when the law goes away. Other counties may interpret it differently. So that would be something, if you have a non-parent custody case and it's not finished yet, and then it's January, you really need to find out how the court in your county is dealing with that. Okay, so moving to the next slide. This is the next level, the next level down, I guess, in terms of strength of legal relationship. So adoption is permanent, non-parent custody / guardianship is not permanent, but it's pretty strong, and it's by court order. Power of attorney is not through a court order. It is based on agreement from the parents, but it does give you custody if the parents sign it. It gives you the power to, make decisions for them about school, make medical decisions, travel with them out of state or out of the country. It can be for up to 2 years. After that, it would have to be redone. So this is based on a new law. It's in the same chapter, Title 11, as the minor guardianship law, but this one actually became, this law came into effect in June of this year. So it's already in effect, and there's already a form available online, which you will get a copy of this PowerPoint, and you'll be able to click on this link. So there's a form available that if you have the parents' agreement, you can fill it out with them, have them sign it, and have them check different things on what powers you will have as the agent. The really important thing to remember about this is that the parents can take it back at any point in time if they write down that they are taking away the power of attorney that they gave you. So this really works when you are working with the parent and they are making, decisions that you agree with in terms of you having custody of the child, etc. But it can be really helpful if you need documentation for things like doctors or schools or anything that, where you get pushback on if you're the one who should be deciding this. In terms of, if you don't think that the parent is going to sign it, or if you think that they'll sign it this week and next week they'll tear it up and say they take it back, then this may not be the best option for you. And that's when you would look at filing for guardianship and actually getting a court order that gives you custody, because that can't be taken away if the parent changes their mind. Like, they have to go to court to change it. In terms of power of attorney and planning for who will care for the child if you pass away, there isn't an option to do successor guardian or name a guardian in your will. So like Anna mentioned earlier, it would be a good idea to gather information about who you think should take care of the child, and write down your thoughts, so that it will show that you were thinking about it and show, your intent, and be evidence in a potential, disagreement. But it doesn't have, there isn't really a legal step that you can take in that situation. Okay, moving to the next slide. Okay, the temporary parental consent form, many of you may have heard of this. It's been around longer than that power of attorney that I just talked about. So it's actually very, very similar. It's almost the same. The power of attorney form is something that is based on a specific law that we just got in Washington that says there's power, a parent can give power of attorney specifically for custody of a child. So this form was made before that law existed, and this form was made basically with the idea that parents who may be deported would need to sign something ahead of time, so that people here could take care of their children if their children were citizens. So, but it's not limited to undocumented parents, but that's where this came from. That's a little history of it. So it really, it's a document that shows that the parents agree that this other person should be taking care of their child, signing them up for school, all of those things. And it's not based on a specific law in the state of Washington. So, and another difference between it and the power of attorney is that this one doesn't really have any deadlines or time limits. It's set by the parents. And you'll remember with the power of attorney, that one can be maximum 2 years and then has to be signed again. But it doesn't, power of attorney, the parent could sign one that just says 6 months or whatever. So these are really similar, and I think that if you use the power of attorney form or this, you will have the same, if they have the same legal binding, which is that the parents can take it away whenever they decide they want to take it away. And the planning ahead, in terms of this form, is the same as with the power of attorney. You don't have the option to appoint a successor guardian. You don't have the option to name a guardian in your will. So it's really about talking to people ahead of time who you want to try to get custody of the child if you were to get sick or incapacitated or pass away, and really work on making that plan before those things happen. All right, so moving to the next slide. This is the last one on the list of legal relationships, going from strongest, most permanent to least strong. This one, I included it because I know there are lots of people who do not have any legal custody or written agreements. There are lots of people who have their grandchildren or their younger sibling or their niece or nephew just living with them. And it's a little bit up in the air if the parent or parents are going to show back up or, come try to take care of their child or take their child from you. And there are a few things to know if you're in this situation. There are some legal rights in Washington that you still have, even if you don't have any written documents for custody, including being able to enroll the child in school and make educational decisions. There's a federal law called the McKinney-Vento Act, and it was written to cover homeless children, but it's written very broadly, and it says a child who lives without their parents, or a child who's living with, basically, I think it says a child who's not living with their parents. Then the school can allow other adults or a kinship caregiver to be the person who is making decisions for the child about the schooling. So that is an important thing to know. It's a federal law. So if a school is giving you trouble, that's something to ask them about, because schools are supposed to have a McKinney-Vento liaison, and they would know what this law means for you. And another law in Washington that we have is in caregiver consent to, or responsibility for medical care. So even if you don't have any form of legal custody, there is a law that says doctors can accept decisions from caregivers for children on their medical care if the caregiver signs a form that says, I'm taking responsibility for this minor's health care. They live with me, all of these different things. There's a form also available online specifically for Washington that you can fill out. So, and I have heard from a lot of people that medical clinics don't know about this form and give pushback to kinship caregivers. So really important that you fill out the form, you sign it. It's basically you saying, I'm the person in charge of this child right now, and I will make their medical decisions for them. And medical medical providers can accept that, and they are supposed to accept that. So similarly to power of attorney or the temporary parental consent form, in terms of planning ahead, it's the same situation where there's no legal avenue for you to name a guardian in case of your death. And so again, planning ahead and talking to someone about that person trying to become the guardian if something happens to you is really important. All right, I think that might be my last slide.
Thank you so much, Celeste. We have a question from Kathy Callahan-Clem, who would like to unmute and ask her question directly, I believe. So do you know how to unmute? You press the,
Yeah.
Okay,
Yeah.
great. Go ahead.
Celeste, hi. Thank you.
Hello.
And thank you, Anna, and thank you everyone for doing this. It's absolutely amazing that we get this kind of support, and I really wanted to say I appreciate it. The question I had is, my husband and I have adopted our grandson, and that adoption is final. And we can we can make a will or legal document that directs who would care for him if something happened to us. But my understanding was that you cannot, that the state of Washington, if something happens to me and my husband, if we die, and let's say my niece takes Matthew in, she can't get any of the post-adoption support. That dies with me. Is that correct, or do you know? Because it doesn't say that in the papers. They told me that. And I have a grandmother who's caring for her granddaughter, who used to be in custody of great-grandma, and great-grandma said when the kid was 11, I can't take this, you take her. And the state said, oh, well, then you can't get the post-adoption support stipend. I guess someone can't be readopted or something. I don't exactly understand it myself. I was just wondering if you knew anything about that.
I actually don't know the answer to that question at the moment because I don't know the specifics of the state adoption assistance beyond what I mentioned earlier in the presentation.
Okay.
I try to find out. I'm writing down these questions, so if I don't know the answer off the top of my head, I don't want to pretend like I know. So, but I am keeping track of the questions and we'll try to find answers.
Thank you.
Thanks, Celeste. We also have a question from Victoria O'Banion, and she typed hers in the chat. And I believe her question was whether or not a foster parent could get a Title 11 minor guardianship. Feel free to unmute yourself if I've gotten your question wrong, but I believe that's it.
So the Title 11 minor guardianship law does interact with the foster care system and dependency laws in the same way that non-parent custody does or did. And that is that if there is a dependency case where the child is placed with you, but there's still court proceedings about the parents and you're, say, the foster parent, the only way to file for a Title 11 guardianship is if the parents agree. And the state, so the Attorney General who represents DCYF and goes to the court hearings, they would also have to agree. So it's a little more difficult to do it. I mean, it might not be more difficult, but if there's already a foster care situation, then it has to be done. It basically has to be approved through the dependency court first, and the state and the parents have to agree that it should happen. So it's not impossible, but you're interacting with another court. Okay.
Shelley Warden had a question, but I believe it was answered by Sarah. So the next question we have is from Susan Duffy, who asks that she has temporary non-parental custody of her 2 grandkids, and they have court trial dates set for May 3rd. A court took this case and has talked to all parties and received all documents. Will the case still make the final decisions and notify us sooner than May?
And just to clarify, one thing is the CASA was making the decision. CASA was assigned, had the document, interviewed everyone.
Okay, so that's a good question, and it's really hard to know what will happen without knowing which county your case is in and what that county plans to do with non-parent.
King County.
King County? Okay, so what I do know is that King County has already announced that if your non-parent custody case is finished at the end of December, it will be dismissed. And that means it will be closed with no decision, and you'll have to file for guardianship. So in terms of a CASA making a report and recommendation, the CASA has to give that to the court, and the judge still makes the final decision. So, and they often listen to the CASA's recommendations, but the CASA doesn't make the final decision. So the really important thing to do, if you have an attorney, talk to that attorney about what's going on in the case. If you don't have an attorney, I would say email the judge if you know who your assigned judge is and say, are we going to finish this case before December 31st? You know, because that's what has to be done if you want it to be finished.
Thank you. Thank you so much, Celeste. That is not very heartwarming news, is it? That's very
No. Yeah, I'm sorry for my answer is, I don't want it to sound harsh, but what I know about King County is that they're not doing any kind of grace period. And so it's really important to know that if possible, try to get your case finished before the end of the year. If not, if that's not going to be possible, start thinking about how to file for guardianship after January 1st.
Thank you. So we have a couple of more questions, but I think what we're going to do, because we need to hear from Zan, and she has a lot of great information to share with us. We'll hold those questions until Zan's done, if that's all right with everyone. And we'll turn it over right now to give us a really thorough discussion. So Zan's going to take over the slides. I believe Zan might be muted.
Can you hear me?
Yes.
Okay. I did that thing where my screen is small again.
Yeah. If you want, Danica can move your slides for you.
Let me just move this over. Hold on. Okay. So welcome everybody. Thank you so much for the invitation to speak tonight, Anna. So my name is Zan Gerson. I'm an estate planning attorney. I spent 6 years working at a firm downtown, and then I left and started my own practice. So I've been on my own for a while, and I work with clients in kind of the Seattle, Greater Puget Sound area. What I want to talk to you tonight, so we've kind of walked through already the, the different legal relationships you have with the children in your life, grandchildren, et cetera, in your life. And I want to take a step back and talk about the estate planning documents that kind of everyone really needs, and why you need them and what happens if you don't have them. So this first slide is talking, so when people come to me, it's always driven by, I need a will. And that's great. You do need a will, but you also need some other stuff. And so the full suite of estate planning documents is really, in the vicinity of 5 to 6 documents, and it's these on the screen right now. So we have a couple documents that operate while you're alive, but if you're incapacitated. And so these are things like your durable powers of attorney and your living will. And then there's the documents that operate once you've passed, and that's going to be a will. We'll talk a little bit about organ donation. We'll talk about the disposition of remains. So the first document that I want to talk about is a financial durable power of attorney. Sometimes these are called general durable power of attorneys. And these are documents, this is a document that allows you to name someone to act on your behalf in the event that you're alive, but you're incapacitated for an extended period of time, to manage your financial affairs. So this is going to be everything from paying your mortgage, your rent, to your utilities, dealing with medical billing issues. If you have a longer period of incapacity, if we're thinking of a situation, Alzheimer's or dementia type thing, we're looking at someone who can file your taxes each year, get you set up for long-term care, and possibly start making transfers to get you qualified on Medicaid. Some things to think about when you're thinking about who to appoint for a financial power of attorney is going to be someone that you actually do trust to do this job. I mean, that's true of any fiduciary role we're going to talk about tonight. But also think about who has the financial acumen to do these things. Who do you know within your orbit that can really do this for you? And then also the consideration of in-state versus out-of-state, right? So, it used to be that I'd say, we should really have someone locally, maybe not far away. It feels more prevalent now with the pandemic that people are here, they can do things, but it is something to consider if you want someone in-state versus out-of-state. So as we go, I'm going to try to answer some of your questions that was kind of the frequently asked questions. And so one of them is, what if I get Alzheimer's and I don't have a financial power of attorney? What options are available? Is there someone who can step into my shoes? And really at this point, the only option that we have is going through a full-blown guardianship process for you. And so that's a big deal. Guardianship in Washington, as I'm sure some of you already know, is a big step. We're actually having you deemed incapacitated legally. It's costly. It takes a minimum of 60 days from the date of filing to get a guardian appointed, which means nothing can happen in that interim period. And those guardians, once they are actually appointed, you need to be filing every year, every 2 years, 3 years, depending on what your asset situation looks like. It's a decision to go through a guardianship process. It's not easy. The other question I get a lot is, well, okay, so I don't want to go through a guardianship. Can I just add somebody to my bank account? And a lot of people do this, right? You see account, it's co-owned with one of your children. Yes, you can. You can add a name on your bank account. But for a lot of people, this is not a desirable situation. For the most part, standard bank accounts are held as what are called joint tenants of survivorship. That designation means that at your death, those assets pass directly to that person. And that may be fine if that's what you want, but it means that they're not going to pass under your will where maybe you're leaving things to multiple people, right? So you set up a will, it gives everything to your 3 children, but you put one daughter on the bank account that has most of your money. You pass away, your daughter gets all of that money. Your other children don't get anything. This can really thwart your planning that you've done under your will. The second reason, the second issue is that the co-owner of your bank account really has full ownership rights. So if I go out and open an account, I put money into it, I put Celeste as my co-owner, she can go and empty my account and there's really nothing I can do about it. She's listed as a co-owner, she has full access to withdraw the funds. And this goes into the last one, which is that co-owners are not subject to fiduciary standards. They really are just an owner. So they're not required to do what's in your best interest. They can just take that money. So for those reasons, we generally recommend against naming someone as a co-owner on your accounts. The next document is a healthcare durable power of attorney. So this is the same idea. This is a document that appoints someone to make medical decisions for you if you're alive but incapacitated. So this is going to be giving and withholding consent to treatment, long-term care planning, end-of-life decisions. I always put this one part on my slide, which is that, because I get this question frequently, death with dignity is not something your agent, your healthcare agent can authorize for you if you don't have capacity. So you don't need to be concerned about that. Things to think about, same idea. You want someone who's aligned with you, who you would trust to make these medical decisions. Again, in-state versus out-of-state thing is a lot more complicated with a pandemic. Sure, doctors and hospitals can call people, but you might want someone closer for that reason, that they can actually come down and be present there. So what happens if you, say, have a long-term incapacity situation and you don't have a healthcare power of attorney? Who is allowed to make medical decisions for you? So in Washington, we have a statute that sets forth who the default decision makers are. And this list, I've listed it here. It starts with your guardian, and then we have the agent under your healthcare power of attorney, and then we kind of run down the list. And so what'll happen is the hospital will start reading down the list of, who do we have? Is there a spouse or a registered domestic partner? No. Then we go to children. Can we find children? And we keep going down until they find a class of people that can make a decision. One of the big kind of catches to this list is that if there's more than 2 people in a class, they have to unanimously agree. And for a lot of people, the class of children or maybe your parents or siblings are just, that they're not going to agree. And this can be really difficult for families if they get into this situation. So for that reason, it makes more sense to have you execute a healthcare power of attorney, name the person or persons that you want, and you don't have to worry about people having to agree that are going to make things difficult for you. The next document is called your healthcare directive or a living will. So a living will is a document that allows you to set forth your healthcare decisions in the event that you are diagnosed with what's called a terminal condition or permanent unconscious state. So this is a situation where 2 physicians have signed off that your condition will lead to your death within a reasonable period of time. that you are currently incapacitated, you can't make your own decision. And the question is, do you want artificially provided nutrition, hydration, or do you want machines, keep life support machines continued or withheld or withdrawn from treatment? As you're thinking through this is sort of, I don't know if people remember this example gets more and more dated as time goes on, but this is the kind of Terri Schiavo situation of, a long-term prognosis, permanent vegetative state. She was not going to recover. And so this is the withdrawal, all life-sustaining treatment option. Some things to think about with this is making sure that your healthcare agent agrees and would do this for you. There are people who, have personal feelings or religious beliefs around this who might love you and want to be willing to, be your healthcare agent, but at the end of the day are not going to carry out the terms of this. So really think and talk to them about what you want and what you're looking for. You may also think about, we do have in Washington what's called a mental health advance directive. So this is more of an in-depth situation planning, advanced planning for if you are concerned about having any sort of long-term dementia, Alzheimer's type diagnoses. And yeah, just talking to your agent, the healthcare directive is a very narrow document. It's really only addressing 2 situations. And so, a lot of your end of your life may not go through this path or these 2 paths. So it's really important to talk about what your values are, when you would want, life sustaining treatment or care and things like that in other scenarios. So the question is, what if I get Alzheimer's and I don't have a healthcare directive? What does my agent do? How does my healthcare agent that I've appointed under my power of attorney act on my behalf? So your agent is required to follow any written wishes. And so that would be your healthcare directive. They need to follow any wishes that you've expressed to them verbally. And then if they don't know, because you've never talked about this situation before, then they're just required to make a decision in your best interest given the circumstances. So the more you share with them, the more likely they are to make a decision that really aligns with what you would want in this situation. Organ donation. So if you have a heart icon on your driver's license in Washington, then that means you have signed up for the organ donation registry. Being an organ donor with the heart icon means that you've agreed to donate tissues and organs for research and transplant purposes. There is a website that you can visit that's called donatelifetoday.com. You log in with your driver's license information, and you can make some limitations on your gift within that website. You can also, if you accidentally signed up for this or you no longer want to be an organ donor, but you still have that heart icon and your license isn't up for a while, you can remove yourself from the registry there. And if you don't have the heart icon and you want to sign up, you can go to that website and sign for it. So for having a heart icon means you've agreed to donate. If you don't have the heart icon and you don't have anything else in place, it's really going to be up to your healthcare agent to make that decision for you if and when the time comes, if it's appropriate for you. If you are really adamantly against being an organ donor, or if you don't believe in it, and you want to make sure, you definitely want to make sure you're off the registry. And then you want to execute an additional document that's called a refusal to donate. And it's really just a straightforward document that says, I don't want to donate my organs. And that can be done as part of your estate planning process. For minors, and this is actually something I learned when I put this presentation together, we learned that a minor, so if you're wondering, you get your driver's license, when you're 16 or 15 and a half actually, a minor can agree to make a gift, an anatomical gift, if they're emancipated from their parents or they're 15 and a half years old and authorized to apply for a driver's license. So this is a binding donation on the driver's license. It's my understanding in practice that hospitals frequently do still talk to next of kin about it. I worked for a firm that represented some hospitals, and I can tell you they don't really want to get into a fight over this with a family. So, but you should just kind of operate that it is actually a binding donation. So the last of what we call the ancillary documents, the documents that aren't your will, is called the Directive for Remains. And this is a document that lets you set forth your wishes for what you want to have happen to your body after death, can nominate someone to handle the disposition. And if you have any instructions or preferences for a memorial service or location for scattering ashes, burial, things like that. So in Washington, we have burial and cremation. And then after, in May of this year, we recently had passed a bill that allows what's called recomposition, or is essentially composting, and also one for alkaline hydrolysis, which is a water-based cremation method that I am told is more environmentally friendly than standard cremation. Right now, we don't have a commercial provider for recomposition or aquamation here in Washington, but I would expect within the next, probably by next year, we will have some services up and running. And again, if you have any location, if you want to be scattered, have ashes scattered somewhere, cemetery you want to be buried in, you can put all of that in this document. As you're thinking about this planning, obviously cost and feasibility of what you're asking, I can write in that you can go to the moon, but if your state doesn't have enough to send you there, I can't make that happen. So think about what's cost, what your state can afford and what's feasible for your family and the people, carrying out these wishes. If you're looking for prepaid services, there are a couple here in Washington. People's Memorial is a nice one. They sort of take the pressure sales out of end-of-life planning. And Neptune Society is the other one that I've heard good things about. So if you pass away without designating someone to handle your remains, or if you don't prepay for any services, and you have family members, children, grandchildren who are disagreeing over what should happen, how do they proceed? Who is in charge? Again, we have a state statute that tells us what the list is in order of priority. And so here, again, we have the agent you've listed in your directive, and then we go to spouse. And then if you notice, this statute actually says a majority of your surviving adult children. So we're not dealing with a unanimous decision again. And then it goes down from there. And you'll also notice that a lot of times guardianship, if a guardian was appointed for your state for some reason, the guardian's actually at the bottom of this list, which is unusual. So there is an opportunity for your family to make a decision over the guardian's wishes in this instance. Okay. So moving on to the will. What is a will fundamentally? A will is a document that transfers your property after death. It appoints someone to administer and settle your estate and all the affairs of your estate. And if appropriate, it also appoints a guardian for any of your minor children. And when I speak of minor children, I'm speaking specifically of adopted or biological children. As we learned previously from what Celeste and Anna told us, I understand there's a lot of other options, or there's a lot of other legal relationships, but as far as the will is concerned, the one that we're most concerned with is the biological or adopted child. For clients, there's really 3 scenarios, 2 if you're unmarried, but we always talk about, so in planning, it's what happens if you pass and you have a surviving spouse? What happens if the 2 of you pass and there are children or grandchildren or other descendants? And then what happens if you and all of your descendants pass? And so there's kind of 3 different layers of planning to think about. 2 if you're not married. And then the other thing to kind of keep in mind on top of those 3 scenarios is there anyone else who's financially dependent on you and who would suffer financially if you were to pass away? And so really think about who that person is and how they might be able to benefit from your estate. Something else to kind of be thinking of. Your estate, we're thinking of your estate from like a value perspective, is really everything you own at death. And so this is going to be bank accounts. This is going to be any real estate, the equity you have in any real estate that you own, retirement accounts and pensions, 401ks, IRAs, Roth IRAs, things like that. We're looking at life insurance, whether it's through your employer or privately. We have vehicles, and then tangible property, which is just your stuff. Most people think about their stuff and they don't think it's worth very much. It's just furniture and clothing and things. But, you know, if you have any jewelry or family heirlooms or something that might, a collection of some kind that might be worth something, is worth thinking about as an asset of your estate as well. If you're married, I'm not going to get too far into this for this presentation, but if you're married, your estate and what's controlled by your will at death is 100% of your separate property and 50% of your community property. In Washington, we're a community property state. Everything you earn or acquire during the marriage by you and your spouse is owned 50% by each of you, and your will owns that 50%, or your will distributes that 50% at your death. Separate property is property that you bring to the marriage and you maintain as separate during the marriage, or a gift or inheritance that you receive and keep separate during the marriage. So when we're thinking about beneficiaries of our estate, there's sort of 3 different options for distribution. You can leave money or assets or property outright to somebody. This means you just give it to them, they take it, it's theirs. It's the most basic distribution. An outright distribution, for being simple, simply means that you trust this person with this money. You can't put any restrictions on their use of this money. Things that say, it's my hope and desire that you use this for college, is not binding on a beneficiary of an outright distribution. But so it'll be subject to their complete control if they receive it. For others, we might consider what's called a custodial account, or a uniform, sometimes called an UTMA or an UGMA account, depending on where you're from. This is going to be that very basic custodial account. You name an adult to look over the money, usually for a minor. It doesn't cost very much to set up. It's useful for small bequests to people. The downside is that it can't be used for anyone over the age of 25. So our UTMA rules, 25 is the latest age. It has to distribute all of that money. And the use provisions are fairly broad, and we'll talk about this a little bit more on the next slide. But the money is basically there for that person. It's owned by the child in terms of under their social security number. And it's really there for their benefit. The third option is to use an actual trust called a testamentary trust that you put under your will. So this isn't something that exists while you're alive. This is only funded at your death for the benefit of a beneficiary. A trust there's a lot of different trusts out there, and if you go down the Google rabbit hole on trust, you're just likely going to end up confused. This is a testamentary trust. You can put your own restrictions on distributions. The assets that are held in that trust are protected from the beneficiary's creditors or spouses. The trust itself can qualify as a special needs trust if we're thinking about anyone who's qualified for Medicaid or has some other state benefits that need to be planned around. There's tax benefits to it, which may or may not be applicable to you. And you can also name someone, again, we're naming someone else a trustee to be the person overseeing those assets. The testamentary trust cons, it's a little bit more complicated. You do need to choose a trustee and think about, because they have a much stronger role than a custodian, and their annual tax filings. And I'm going to take 1 second to text my husband to deal with my screaming child next door to me. Thank you. So with the testamentary trust, it is more complicated, and so it's worth thinking through whether it makes sense. So when should you consider one versus the other? I was asked this doing a presentation to put a number, and I was really hesitant to do this in that presentation, and I'm hesitant to do it here now, but to say that I don't think it makes a lot of sense for the most part to do a testamentary trust for anything under $250,000. It's not a bar, that's not written anywhere. That's just my personal feeling. I think it's not worth the effort, the filings, all of the work that needs to be done for the trust. And so that's kind of where I think of the line is. That said, you can see on this chart, we have some differences between the two. So custodial account, you choose which age it pays out at. It can pay out at 18, 21, or 25. In a testamentary trust, you can choose any age you want. So I have a lot of clients keep the money in the trust until their child turns 30, 35, even beyond. For a custodial account, the distribution under state laws and as a statutory type of account, it's for the use and benefit of a minor. That's pretty broad. That doesn't have a lot of restrictions on it. In a testamentary trust, we can put a lot more restrictions around what the money can be used for. The custodian trustee, again, both are named under your will. There's no creditor protection on an account for a minor, whereas a testamentary trust there is. And then the last one is the Medicaid issue. I say that it is included for Medicaid, and that's mostly true. There might be some gray area there, but you should assume that it is. Whereas a testamentary trust, if we're really planning around some needs-based benefits, that we want to do a special needs trust, and that's a whole other type of trust that we can do. So the next thing your will does is appoint fiduciaries, the people who are sort of going to be in charge of various parts of your estate. The first one is the personal representative or executor. So this is the person that's actually going to step into your shoes at death and administer your estate. They're going to hire a lawyer, probably like me, to open the probate proceeding, submit your will to probate. They're going to get back what are called letters testamentary that give them the authority to act on your behalf, and then they're going to go out and settle your estate. That mainly includes collecting and inventorying all of your assets, paying creditors, ascertaining and paying any creditors that you might have, filing your final income tax returns, and ultimately distributing the assets to the beneficiaries. This is a role that has an end date. When probate is over and we close probate, your personal representative is released from their duties. And probate typically takes anywhere from 6 months to a year. For small estates, it can take upwards towards 2 years if you have a much more higher net worth, complex estate. I do want to say that probate gets a very bad rap from people. It's actually very straightforward in Washington if you die with a will. It's not something that I think is worth over planning to avoid. And so for most clients, especially on my probate side, it's very straightforward. It's not particularly expensive. So. The next role is, like I was just talking about, the trustee or custodian, the person who'd be managing these assets, likely for a minor beneficiary. Again, we're going back to, you want somebody who is financially savvy enough to know how to manage the assets, file tax returns, and communicate with the beneficiary. And they'll be communicating with the beneficiary or the guardian to determine the distributions. This is a role that's going to end until that trust or that custodial account ends. And then the guardian, so again, you can nominate a guardian in your will for your adopted or biological children if they're under 18. And so this is the person that actually steps in and goes through the process of getting guardianship and getting physical custody of your children. And that role again ends when the child turns 18. So things to think about when you're thinking about your fiduciaries. This is really a job. It's not an honor. It's not something that should be, I have people who think that certain children deserve to have this role because of whatever reason. This is really a job, and the personal representative role is quite a bit of work. So really think about it from that perspective. There are professionals out there who do this. Obviously, it's going to cost your estate more money, but it may be worth considering if you have a contentious situation with maybe children or family members. We're back to that in-state versus out-of-state question. For probate, there's a lot of stuff in-state that needs to be done. Someone needs to go into your house and clean it out and get it on the market and sell it and things like that. You need somebody here for that. Really think through, as you're making a list of the people in your life to ask to do these roles, really think through about where they are and their ability to take this on, and their understanding of financial things. And as far as co-fiduciaries, people wanting to name 2 children or 2 people, this is almost never a convenience. I know it seems like it is, but in most situations, it's more of a burden. A lot of banks and other institutions want to see both people there, which means that you're not really getting around the splitting of duties. And there's a lot of litigation around co-fiduciaries, one person doing something they shouldn't. And it's just, I would say generally, I pretty much always advise against it. So what happens if, my husband dies intestate without a will and his children from a prior marriage are clamoring for his money as a spouse, do I get everything? Or what happens if I die without a will and I'm unmarried or I haven't remarried? So again, we do have a state statute that says where your assets go when you die. This is the default in Washington. If you are married, we have the left side, all of your community property. So again, all that stuff that you've earned during your marriage is going to go to your spouse. And if you have separate property, then it splits up depending on whether you have children or not. So we have 50% to spouse, 50 to kids, and more remote descendants, and then 75 to spouse, to parents or descendants of parents. And then if there are no descendants of your parents, we're going down and it goes to your spouse. If you do not have a spouse, we're going down children, grandchildren down the line that way. And if you don't have anyone in that family tree branch, you go up to your parents and you kind of start working your way back down the family tree there. If we can't find anyone from descendants of your grandparents, which is a very large portion, your money can actually eventually, what's called escheat to the estate, or to the state, which means that it goes to the state of Washington. But that's a lot of people to have to search through, and it very infrequently happens. If you die without a will, who would be appointed to oversee the administration of your estate? So again, we have a list here in Washington in order of priority. Looks a lot like all the other ones we've seen, which is goes down the line: spouse, children, parents, brothers, sisters, grandchildren, and down. So this is a pretty long list. It's worth keeping in mind that dying without a will, it's going to be more expensive. These people will very likely have to post bond. They may not get what we call non-intervention powers, which is the ability to administer your estate without court approval or court involvement. Both of those things cost money and make intestate estates much more expensive to administer. So for that reason, I would even though we have these statutes that say where your assets go, I would strongly recommend doing a will. What happens to my minor children or grandchildren or adopted children if you die without a will? So we'd still have a guardianship proceeding, assuming you have assets passing. We still have a guardianship proceeding. Really, the guardian ad litem, that third party appointed by the court to sort of investigate, is going to look around and see who's available. You're not going to have any say in that without a will. As far as your assets, everything, if you die without a will, all of your assets go into a custodial account until your child turns 18, and then they get full access to it. So it's worth really thinking that through how much of your estate, how much your estate is worth, the equity in your house, perhaps other assets, if you really want that child to have access when they're 18. A lot of people think that that's far too young to have sort of freewheeling access to that much money. And so that's why we recommend the custodial account or the testamentary trust. So two situations. So what if I have a document saying I give everything to my granddaughter and I sign and date it? Is that a valid will? And the answer is no. And you say I already have a will and I signed and dated it in front of a notary. Is that a valid will? No. In Washington, your will must be signed in the presence of two competent disinterested witnesses, and the witnesses must sign the will at your direction and in your presence. Frequently, there's also what's called an affidavit or a declaration attached to your will, which is really a function of getting it admitted to court later. We do not recognize holographic wills in Washington. Holographic meaning wills that are not signed with two disinterested witnesses. They are not valid at all. They are nothing. So if you have something that's been signed, the notary one is the one I see the most, that is not valid. I cannot probate that. It's not even, it has no binding authority on anything we're going to do probate proceeding. So it's really a black and white situation in terms of what is a valid will and what is not. And then we have, but really, why shouldn't I use the free online will template? I get it. Estate planning, lawyers are expensive. There's a lot of free options out there. And this is what I'm going to tell you, having practiced for a decade in this area. Online wills are, the biggest thing is that they're a generic form. They're designed to sort of be what most people want. And there's really not a lot of options out there beyond their sort of default. And so for a lot of people, they just don't fit what you're trying to do. the benefit of having an attorney is to have someone listen to your story and figure out the best sort of mechanism for distributing your estate based on your situation. And along the way, we ask questions, and we sort of, the answers I get from clients direct my advice. And so not having that, you don't know what questions to ask yourself. You don't know where your situation differs from kind of the norm. And so it's sort of the you don't know what you don't know situation. And so for a lot of people, it's just not a sufficient form. You know, any service that's offering an attorney review is really just making sure you filled in the blanks. It's not actually advising you in any capacity. And then to go kind of back to my prior slide, a valid will in Washington is enforceable regardless of the outcome. And I have seen some very, very awful, contradictory online free wills in probate proceedings being litigated by all of the beneficiaries, because at the end of the day, if you signed it in front of two disinterested witnesses, we have to take it to court and we have to figure out what's going on. And that's going to be expensive and costly to your state and to your heirs. And on the flip side, an improperly signed will, a will that you thought was valid, but didn't sign, in front of two witnesses, is not enforceable. And so maybe you're sitting and thinking that you did something that is going to be followed, and it turns out when we get there, it's not actually. So that's my pitch to go find an attorney. There's a lot of resources, and I'm sure Anna, Celeste, and I can help direct you and to find a lawyer that can help you kind of work through these things. And so then the last thing I want to talk a little bit about just very quickly is non-probate assets. So non-probate assets are assets that pass at death according to a beneficiary designation on the contract or due to the titling on the account. So the titling, going back to kind of the beginning of that slide with the joint tenants with rights of survivorship, like I said, this is pretty much the default on all standard checking and savings accounts if you have co-owners. Again, that means the death of one co-owner, all the money goes to the survivor. It can also be a way to hold real estate, and you can get that changed with a deed if you need to. But again, it's the idea there is that the title directs the distribution at death. Other accounts, we have beneficiary designations. You're going to recognize these from retirement accounts, life insurance, annuities. Sometimes your bank accounts have a payable on death, transfer on death designation. And we also have in Washington what's called a transfer on death deed. Again, these are things, so it's kind of on that contract where it goes. The most important thing is making sure that you know what you've done on these non-probate assets, and then it lines up with what your will says. So we want to make sure that whatever you're doing, if you're giving money equally to kids, that we don't have one child named as a beneficiary on everything else in your estate. And for a lot of clients, retirement, life insurance are two of the bigger assets that they have. So it's important to kind of check those things out and make sure that they're all set. And I think that is it for me.
Thank you so much, Zan. That was very informative. We're running tight on time, so we won't be able to get to everyone's questions, I'm afraid. But please, we're going to share our emails at the end, so feel free to email, or I know Celeste has taken all the questions, and we'll get the answers to you. I just want to ask you a couple things, Zan. Sure. From Kathy, if you're against life support and artificial nutrition and hydration, does that mean the hospital would allow you to slowly starve or die of thirst as long as you kept breathing and had a heartbeat?
That's a good question for a doctor. I mean, I obviously I can't speak to the experience. My understanding is that I don't know that you, this isn't a situation where you're asking for something. So if you're conscious enough to ask for water or food, they aren't going to withhold it from you. This is you are fully incapacitated. These things are keeping you alive. Do you want to continue or not? It's not that you're asking for something and they're not giving it to you.
Okay. And Ms. Bell, Jackie Bell, if you'd like to take yourself off mute and ask Zan your question directly.
Hi, Zan. Unfortunately, my sister passed away in January, and we were not even aware of the fact that she was ill. And through default, I kind of became the decision maker of her estate. Mm-hmm. And she had on her driver's license that little heart. Mm-hmm. And we did not know that. And so if a person like my mom was very adamant about, we're not going to do that. We're not going to do that. But it was on there. And so Life Resources and some different people began to call me and say, well, she signed and we're going to do this. What options, if any, are there in those situations?
Oh, that's a good question. Did they talk to you at the hospital? I mean, my understanding was that the hospital would still talk to next of kin, but I don't know that if they've signed up that you do, like, legally, that you have any options other than just making a big fuss at the hospital and not wanting them to get involved with it. So,
excuse me for interrupting. What we experienced was, because she had that little heart thing on there, they said that she had already made the decision when she was in a state where she could, and that had to be honored, and there were people waiting for the organs. And so, like, that was in January. This is now November. I still get phone calls from them asking about, what about different things? Do you have other family members you want that would be interested in this service? So I would just like to encourage anybody, if you have that on your license, please make sure your family members know that.
And I would say that's true for any of your estate planning wishes, is making sure that the people that you've named know that they're named in these roles and they know what you want and that this is clear. Because you don't want that situation. It's a hard enough situation to deal with, someone who's incapacitated for a long period of time or someone who dies. You don't want your family fighting over it. You just want them to know, this is the person that's in charge. These are my wishes. This is what's going to happen next. So I'm sorry that happened to you and that they're still calling you.
Thank you, Zan. I appreciate it. Thank you, everyone.
Thank you. So I want to respect everyone's time, but if you want, we could stay on for a few minutes and answer the remaining questions, if that's good with everyone. Okay. All right. And for whoever wants to get off can, and then we'll get this. I'll have if Danica would put up the slides so that you can have our contact information on the last slide for anyone who needs to get off as we go through the questions. So Zan, so if the husband dies and all the account of the property is in his name and doesn't want to have anything, and doesn't have anything in her name, who would all the assets and stuff go to?
So assuming that you acquired all of that property during your marriage, it is still community property. So in Washington, title of property is not indicative of character. And what that means is it doesn't matter that my husband and I have a joint account and two separate accounts. My paycheck that goes, we put money into a joint account and then we each take a little bit of our own fund money. That's all community property. It doesn't matter that it's in his name or my name. We both own it 50-50. And there is actually no way while you are married to split it up without doing some sort of postnuptial agreement to definitively divide it. So yes, if all of the property that you've been, paychecks and things like that are in your husband's name, you still own 50% of it.
Thank you. One more here. Does an advance directive also need 2 signatures from non-interested parties?
Yes. So actually, basically every document that I talked about today can be signed in the presence of 2 disinterested witnesses. Who is disinterested kind of depends on which document you're looking at. But I would just find people who are disinterested means, for at least the will side, is these are people who are not related to you. They're not beneficiaries of your estate. They're not heirs of your estate. I want friends that are just friends, right? Or neighbors or something like that. But yes, the healthcare directive, the powers of attorney can be done in 2 disinterested witnesses, or a notary. Directive for remains is 2 witnesses. So yes, the rest of them are 2 witnesses.
Thank you. Thank you, Zan. So we had some questions that we didn't get to when Celeste was speaking. And if you're still online, Holly, would you like to unmute yourself and ask your question?
Yes. We have our grandson who is 3. We've had him since he was born. And the mom has signed her rights off. Dad refuses to sign his rights off, but he is agreeing to third-party custody. What what is the difference between third-party custody and guardianship that I'm afraid we're going to have a problem? So what is the difference between the two?
Well, first of all, if the dad hasn't agreed to non-parent custody and you don't have a final non-parent custody order before the end of the year, then you would probably need to do a guardianship instead, depending on which county you're in.
We're in Cowlitz County.
Okay, so I haven't heard anything about how Cowlitz County will be dealing with the change of the law, cases that are still open, but so that's the first thing to think about and try to, find out what the court is doing, if they even have a plan yet.
Okay, yeah, because we're with CPS still. I mean, like, we're still
okay.
in the whole.
Okay, so basically, non-parent custody, if you get it before the end of the year, then you just have it. And to change it, the dad would have to file to change it or terminate it under the new guardianship law. So the difference between the two won't matter,
right?
Or how to cancel it. If you don't get non-parent custody before the law changes and if the court says that law is gone, you have to file a new one. There are some differences, and it's a lot to kind of go into right now, but guardianship and non-parent custody both still are, custody that you would have the child. You could have a parent, the dad could maybe have visits, which is the same with non-parent custody. The differences are more in what you have to prove about the parents to get custody. It's a little bit different, but not totally different. And if you are starting a guardianship case, there are some differences in terms of who you have to notify about the case, and if the parent may have an attorney appointed to them is a possibility with guardianship, but not non-parent custody.
Well, he has an attorney because, it's in CPS.
Yeah.
So he has an attorney right now, and she's willing to draw up the third-party custody papers, but she has not done that yet.
Mm-hmm.
And so how will this protect us and my grandson? Like, he can't just go decide one day to take him back, can he?
Correct. If you get the non-parent custody file finalized and his lawyer does that, gets his signature, and you get a document that says you have non-parent custody and it's final, correct. The only way that he could get custody back of the child is to file a case in the court and try to prove that there's been huge changes in his situation and that he, so basically he would have to do it through court, or he can't just change his mind.
What about guardianship?
It's the same.
It's the same thing?
Yeah.
And is the only difference that we would have to be, do we have to be foster parents also to do guardianship?
So you do not have to be foster parents to file a petition for guardianship. But if you are already foster parents, then you have to get the dependency court, that's the court that makes decisions about children in foster care, to let you file for guardianship.
Even if we're the grandparents?
Yes.
So we have to petition to.
That's already, if you are doing non-parent custody and you're a foster parent, that means that the court is already letting you do it. Like, it had to get approved.
Like the permanency plan, planning is either third-party custody or adoption. Like, that's what the plan is through CPS.
Yeah.
It's just those two things.
Yeah.
Well, thank you. Thank you for asking your question.
Thank you. Sorry to take up so.
No,
I'm
was
just so
that's it.
confused.
If it's case specific, perhaps you follow up with Celeste through her email or her phone number, because I do want to respect everyone's time tonight since we've gone over a bit. And
All right, thank you.
Thank you for joining us tonight. And I would ask also, there were a couple of people that I didn't get to, and just to please reach out to whomever you want, who you think will be best suited to answer your questions. But we thank you all so much for joining us tonight, and do know that there are efforts underway to create a list of pro bono or low bono estate attorneys who can help you with your case specifics. But at least tonight, I hope you got the ideas of the kind of information you need to collect and the things you need to think about to take it to the next step. And then in the new year, perhaps get things implemented. And you'll hear back from us. We're going to share the slides with you. We'll share resources with you, and we'll follow up as things develop. There are also a few slides there are a few resources in these slides that you'll see when you get the slides, that are free fact sheets and websites that you can refer to for more information in general about kinship care. But it's been a pleasure to have you all with us tonight, and do know that the three of us want to be resources to you. So don't hesitate to reach out on those at any of our email addresses. Zan or Celeste, do you have any parting words here?
I just want to say that email's in the PowerPoint and you'll see it. I just want to remind everyone that in my job, I can't take individual cases or give specific legal advice, but I can give, I can send resources to people. I'm trying to create a list of attorneys who will, you know, be open to having you call them. You know, private attorneys who charge, but potentially less. And that I am open to questions, but I may say that's a question you need, you know, like your own attorney for. But that's what I wanted to say. And if you have questions, I'll try to help you connect with who can answer it if I can't.
Thank you all for joining us. Really appreciate it. I hope you all have a restful evening. It's getting late.